Hello, welcome, and thanks for joining Mayor Brown's webinar today on Dodd-Frank clawback policies, enforcement under foreign law. My name is Ryan Liebel. I'm a partner in the employment and benefits practice in Chicago. Happy to introduce today's program, and welcome to everybody. It's really nice. We had a broad range of RSVPs from people around the world, which we were hoping for, so welcome. Good morning, good afternoon, good evening. I think covers almost everyone, later for some of you than others. So we plan to start with Hong Kong and Asia first, since that's, I think, the latest hour for most people joining. I'm joined today, so if you want to flip the slide for me, please, from partners around the world, from Mayor Brown, Aline in Brazil, Julian in France, Chris in the UK, Hagen in Germany, then myself, Jennifer in Hong Kong, and Jad in Dubai or UAE. So we'll get a lot of different perspectives. So let's get started. Okay, the overall agenda. So as many of you know, the rules are changing greatly in the US this year, hence this program. So we'll start with me giving an overview of sort of how we got here in the US, a high-level overview of the rules. Of course, we could spend an hour or more just on the rules themselves. But we want to spend time talking through, and of course giving everyone in these other jurisdictions a chance to talk through how clawbacks work in their jurisdiction, how the new rules may be applied, and different considerations for you all to consider at this point. So, and then at the end, of course, if we have time, we'll get to questions. So first, the overview in the US. I think it's helpful to back up a little bit. I don't want this to be too much of a history lesson, but I do think it's helpful for a lot of clients to kind of review how we got here, because some of the story helps, to me at least, inform our recommendations for drafting at this point, and some of the differences. So the clawbacks in the US started for public companies really with Sarbanes-Oxley in 2002. This was a statutory provision. It's self-effective. No companies had to take any action. It's a statutory provision that allows the SEC to sue for certain compensation of the CEO and CFO for material restatements if fault is present. And there certainly is overlap between that provision and Dodd-Frank, and there's at least some permissive offset potentially between the two provisions. But just know that that's out there. But also, I want to use it as a contrasting point again, because it's effective just via the statute. Companies didn't have to do anything. It was just passed as law, and then it applies via the SEC. And then the other reason I think this is helpful is this is Dodd-Frank. And for those of you, Dodd-Frank seems in a lot of ways like old news, but there's still parts of it that are popping up. It, of course, was the act passed in 2010 in the US. In response to a lot of the perceived issues with the financial downturn in 2008 and 2009. So this dates back to that. So, but contrasting it to Sarbanes-Oxley, it was not a self-effective statute. What it did, the statute directed the exchanges to establish listing standards that prohibit the listing of any security of a company that does not adopt and implement a written policy requiring the recovery or clawback of certain incentive-based compensation payments. So the statute directed the exchanges. The way that this worked out procedurally is we needed final regs from the SEC directing the exchanges. Then once the regs were final, the exchanges adopted listing standards. Once those were final, companies have 60 days to adopt the policy. So 2010, the statute, 2015, there were proposed regulations passed, and then it took 7 more years for the final regs to be passed. There's, obviously a political gap in the middle. You may identify in the US the reasons, the timing, why it was pushed by certain people and others it was not. But here we are in 2002, it finally gets final regulations. And then in 2003, the stock exchanges have adopted the listing standards, and they dated them to be effective October 2nd, so that the 60-day period would give companies until December 1st to adopt a policy. The policy, though, has to apply to all incentive-based compensation received on or after October 2nd, 2023. The word received in this context has a special meaning from the listing standards and the regulations. It can relate to compensation that was granted years ago. If it's going to become vested or paid, or relate or granted after October 2nd, 2023, it can still be subject to these rules if it was granted or earned prior to October 2nd, 2023, if it's going to be earned or sort of received after. So I do want to note there is a look back potential even with the date set at October 2nd, 2023. The other reason this history part I think is important is in the meantime, over the years, institutional shareholders like ISS and other just sort of large shareholders pushed a lot of public companies to adopt clawback policies that were not required by law. And many of our clients did that. They adopted voluntary policies that are different in a lot of ways than the Dodd-Frank policy. Many of them require fault. Many of them are discretionary. And many of them are done on an after-tax basis, which we'll compare in a minute to Dodd-Frank. So some of our clients are making decisions of, do we update the old policy to cover the new rules? Do we update a separate policy? And different companies are taking different positions on that. But that's the background. So here we are, Dodd-Frank, we have about 6 weeks before all of us with listed companies have to have something in place. Okay, slide. So why have an international panel on the U.S. regulation? I think the first part of this is fairly obvious, right? That it's U.S. listed companies. So many foreign corporations are traded in the U.S. And or many companies with an international footprint may have executives who live or work in foreign jurisdictions, even part of the year, which is another interesting question I've gotten into with some clients. If you allocate income to different locations, how will that work? And the key point here that I want to note again is it is a requirement to adopt a policy. It's mandatory, but the policy is not effectuated by statute. It's effectuated by contract. So if you're in the position of needing to potentially enforce your clawback policy in a foreign jurisdiction, the key is if drafting matters, you have to draft it correctly now to be able to enforce it later. So we felt like it was a good time to try and get in front of everybody to say, hey, if you think you may need to enforce this US-style Dodd-Frank clawback policy in a foreign jurisdiction, you need to think through the drafting now, because if the drafting matters, now is when the policy is going to be put in place. It may be too late under foreign law if you put it in under US law only, or only think through US issues, and then in 3 years you have to do a clawback and you call us and say, well, we need to enforce this in Hong Kong, or we need to enforce this in Germany, or whatever it is. And our German attorneys say, ooh, it would be much better if it said this. So we want to get in front of that and help everybody think through that now. Okay, next slide. So high level coverage of sort of the rules that I want to note, again, contrasting. The basics of the rule are if there's a restatement, and this includes what's known as a big R and little r. I'm not an accountant. I think that means a lot to accountants. To me, really, if it's a restatement that's needed for whatever reason of financial statements, the company has to claw back, mandatory, any compensation that would not have been paid if the correct financial, or if the financial statements had been correct to begin with. That's the overall concept. There's a million nuances to that. There's a lot of different sub rules, but that's the overall concept. And again, no discretion on enforcement. It's mandatory. There are only 3 limited exceptions. The one that will likely be the most useful is if cost of enforcement exceeds recovery. There are still rules that you have to jump through if you want to use this exception. So don't just think you can sort of back of the envelope this and not do it. You really got to go through a full process. But this is sort of the rules equivalent to a de minimis exception. There's no flat de minimis exception, but if it's a really small amount and it would take more money to get it back, you could possibly avoid needing to do the mandatory enforcement. The home country law. Now, I want to note this. Obviously, we're doing an international panel. This does not include situations where you're trying to enforce it against an executive in a foreign country. The home country law exception is if the listed company is a foreign corporation incorporated in a country that had a law on its books prior to November, I think, 22nd, 2022, that would not allow the enforcement of this policy, then that corporation is exempt from these rules. I'm not aware of any client needing that requirement or being able to take that position. It's a very limited exception, but I do want to note it's not a broad one that you may not need to enforce it in another country against an executive. It's just this, if you're incorporated in a jurisdiction that would prohibit this enforcement, then you may be out of this rule. But again, I'm not aware of any companies being able, or any of our clients being able to take that position at this point. And then the last one is a tax qualified plan. You can't jeopardize the qualified status of a qualified retirement plan in the US to get money back out of it, because as many of you know, that's against those rules. The no reduction for taxes paid by the executives. This is a key point in the US, and this may vary by jurisdiction, but the key concept here is that if an executive receives an amount in one tax year in the US, they will pay income tax on it that year. If they have to repay it in a future tax year, it's not as simple as just reducing their income in that future tax year so that it's a tax neutral situation to them. It could be that they lose money. So let's say you overpay them $1 million in 2022, and then in 2024, you ask them to write a check for $1 million. If they do that on an after-tax basis, it would take like $1,600,000 in the US of income to write a check for $1 million. So the executive is not only going to lose $1 million, they're going to lose an extra $600,000 potentially in taxes. The issue here is the SEC was aware of this. The judgment call is the point of the clawback to prohibit executives from profiting off of restatement, or is the point of the clawback to put the company back in the position it would have been had a misstatement never occurred? And for many of the voluntary clawback policies over the years, the companies took the position that we want to prohibit executives from profiting. So they allowed a reduction for the tax issue. So the executives are no better off if something goes wrong. But the SEC came out firmly on the side of the company should be in the same position it would have been in had the restatement been done, had the financials been done correctly to begin with. So there's no reduction for taxes for executives. The other thing I think that the point of this is, if you think through the theory of why they're doing this, they want to incentivize executives to never have a restatement. They want to promote a culture of compliance with companies to make sure that this does not happen. It's the best way to protect executives. And so I think the idea here was we want to make it as helpful to the company as possible, and we're not worried about the impact to the executives because we want to incentivize them to make sure this never happens. Going along that same logic, you can't indemnify the executives. Again, the idea is the company should be no worse off, and we're okay if this is painful to the executives. It's just frankly the answer from the SEC's perspective. We want the company to be made whole, and no fault required. So the Sarbanes-Oxley and many of the voluntary policies require some sort of fault. Not all of them, but many do. This rule specifically, there is no fault concept. It is done without regard to fault. Okay, so some key concepts. We won't cover everything, but I do want to note a couple high-level concepts. We already talked about companies. These rules apply to companies listed or trading on an exchange in the United States. Covered executives are subject to the policy, and this includes current and former executive officers, and this generally uses the Section 16 definition in the US, which generally includes president, CEO type, the CFO, the CAO. That's one I want to note because a lot of people don't think about that, but your chief accounting officer is covered. And if you don't have one, it's whoever is basically in that position for the company or signing or designated as such in the 10K. Vice president of the company in charge of a principal business unit, division, or function. They have a policy-making function or have that level of authority. Companies are already taking a position on who meets this definition. So this should not lead to a lot of new homework for a company. This is something companies have been taking a position on for years. So it's just a matter of identifying these people and making sure that they're covered. It does apply to former executive officers who depart if it relates to compensation they received in relation to the year for which a restatement is required. So it's important to think that through. Current executives have to agree to that. If you have former executives who have departed, you may have trouble making them subject to the current policy unless you had good language in place before. It's a little bit of a tricky question that we can talk through if it comes up for anybody. The erroneously awarded compensation, again, this is the amount that's required to be clawed back. It's basically the amount that exceeds the amount that would have been paid if the financial statements were correct to begin with. But notice the definition of incentive-based compensation. So if you flip the slide, it's not all compensation. Incentive-based compensation, it's subject to the rules, compensation that is vested, granted, earned, or vested wholly or in part on the attainment of a financial reporting measure. So again, these are generally accounting principles. The definition is there. but it also includes stock price and total shareholder return. So if you have a restatement, you have to restate the financial statements. It's going to be easy for the accounting principles because they will be restated by definition in the restatement. The really hard ones will be stock price and total shareholder return. And there's a process for this. But if you have a restatement, you actually have to go back. If you have an award that's earned based on total shareholder return, which many public companies in the United States do now for a few different reasons. One, shareholders love it. ISS loves it. And there's also the new disclosure rules on pay versus performance, where your pay gets compared to total shareholder return. So it's another reason to have it. So it's very popular. But if you have a restatement, you're going to have someone go back and take a position on what the stock would have been worth had the financial statements been correct to begin with, which is going to be very difficult. But I just want to note that it's something that will have to be worked through. And then this is the definition of restatement that, again, we covered earlier. So, okay, slide. Okay, a couple more quick things, and I want to turn it over to the rest of the panel. I noted this before. Policy has to be adopted and effective December 1st, 2023, but it has to apply to compensation received on or after October 2nd, 2023. So there's some nuances there in the drafting. Make sure your drafting is correct to capture both concepts. This is a big point. The clawback rules are mandatory, non-discretionary, and telling you how much you have to claw back. Very mathematical, except for the TSR and the stock point, which will be a little bit more difficult. But again, it's a process that's mandatory. What the rules don't tell companies is how you do it. How do you go about recouping it? So we have recommended for our clients to draft the policy very broadly to permit offset of any future compensation to the extent permitted by law in 409A, to reduce that future compensation by amount needed to cover the offset. And I was hesitant to do this at first because I thought, geez, for executives, they may be really hesitant to sign a policy that allows the company to reach compensation that's broader than the incentive compensation subject to the policy. But the thing is, when you really think about it, the executives may prefer this too. And part of the reason is the tax issue I noted before. It's not clear in the US if you reduce future comp by the offset amount, if you can do it on a pre-tax basis, but there are at least arguments that works. And the arguments are enhanced that works if the policy says that from the beginning. The arguments won't work if you don't do that from the beginning. You try to get the executive's consent later to reduce future comp because the consent will require it then to be taxed. So in our minds, we have provisions we've put in a lot of these policies that very broadly allow clawback of really any future compensation subject to applicable law and, again, 409A. Again, the third bullet, I want to note this again. This is contractual in nature. So our recommendation is you have executives sign an acknowledgement letter that they agree that they're subject to the terms of the policy as granted. And it's not just, so you use a future grant as consideration contractually. You say you will not be eligible for any future grants of incentive-based comp unless you agree to the terms of the policy. But so you have future consideration for the acknowledgement letter, but then the acknowledgement letter and the policy make it clear that it applies to all compensation that may be subject to the policy. And again, that may include compensation that was granted prior to October 2nd, 2023. And then the last point I want to make, two more points, I guess, but one is you want to add a provision in the policy that affirmatively states that to the extent any other document of the company that's with the executive, any other contract or agreement between the company and the executive that's inconsistent with the policy, that the policy supersedes it to the extent inconsistent. I say that because a lot of companies have broad indemnification policies. A lot of companies have reimbursement provisions in employment agreements or other language that could arguably be used by an executive to say, I can use this other contractual provision. You have to pay for my attorney's fees. You have to reimburse me. You have to do this. And it has to be clear that this policy trumps any of those things so that the policy controls. Otherwise, it could be a problem on enforcement. And then the last note I want to note before I turn it over to the panelists is for those of you who work for a company that has an existing policy, and we have some clients that have an existing policy in the US that was voluntary, and then have other policies in other jurisdictions that are required. For example, the UK, they may have a policy in the UK that applies. And so some clients want these rules to just be combined with their existing voluntary policy so that it's under one umbrella. And that works. We're doing that for clients, but I just want to note as a drafting matter, you have to be very careful. Those policies, again, are often discretionary and often contain provisions that are inconsistent with these requirements. So if you do that, you really have to be careful in your drafting that you isolate the requirements so that there's no argument that could be made that the voluntary policy weakens the requirements that are mandatory under this policy. Okay, so with that, I will happily turn it over to Jennifer in Hong Kong. Thanks.
Thanks, Ryan. Good morning, good afternoon, good evening, everyone. I'm Jennifer Tan, partner in Maybank Hong Kong office. In Hong Kong, we do not have any statute which requires or enables an employer to claw back any incentives that are made by mistake. However, employers do come to us for advice from time to time as to the right to request or claw back any payment to the employees made by mistakes. One example is, for example, when a staff is found guilty of a misconduct after a bonus is made, the employer would like to know whether or not they can claw back the amount paid. Naturally, if they are aware of the misconduct at the time when the decision is made, the outcome may be different. And my response will always be, can I have a look at your bonus policy and your employment contract first? Because in Hong Kong, the right of the employers to recover any payment made by mistake boils down to the contract of employment. A clawback policy in Hong Kong is not uncommon. Employers in the banking and insurance industry, they have a regulatory obligations to implement a clawback arrangement in their remuneration system. Failure to comply with the regulatory requirements imposed by the monetary authority by the banks or the insurance authority by the insurers is not an offense, but they will have a negative impact on the regulator's assessment on whether the insurers and the banks, which are licensed corporations in Hong Kong, remain fit and proper for the business. The regulatory requirements imposed by the MA and the IA are similar. The banks and the insurers should include in their remuneration policies provisions which enables them to make adjustments to the incentive before and after it is awarded to the employees if the bonus decision is made based on information which turns out to be inaccurate. The information could be the financial performance of the bank or the insurer as well as the individual performance of the employee. The regulatory clawback and adjustment requirements imposed by the HKMA and HKIA are not binding on employees. So in order to comply with the regulatory requirements, the banks and the insurers, like all other employers in Hong Kong, they will have to reserve the right to recovery by way of contract. Of course, the terms of which must be accepted by the employees. Next slide, please. Turning to enforcement, employers may consider to recover the payment made by mistake by making deductions from any other payments due to the employees. But in Hong Kong, Section 32 of the Employment Ordinance, which governs all employment relationships with Hong Kong, does not allow the employer to make such deduction from any wages or any other sum due to the employees. Breach of Section 32 is a criminal offense. Apart from the employer itself, the directors or officers who endorse such deduction decision may be held personally liable for the breach. There are certain exceptions to this prohibition under Section 32, one of which is to make deduction for recovery of overpayment of wages. Wages is a defined term under the EO, which in essence means any payment for work done or to be done by the employee, but it does not include any annual contractual or discretionary bonus or payments to the employee. So depending on the structure of the incentive, if they are not wages in the outset, then the employer may not be able to make deduction from wages from the employees for recovery of the overpayment of the incentive. Even if the employer can lawfully recover the money by making deduction from the wages, the amount which they may deduct in one wage period, generally is 1 month in Hong Kong, must not exceed 25% of the amount payable in the same wage period. So if the amount you need to recover from the employee is huge, then the recovery process could take some time. Of course, if the employee has a contractual obligations to repay the payment to the employer, the employer can sue for breach of contract if they fail to do so. Again, depending on the amount involved, some employers, in my experience, may not pursue the claim as litigation takes time, and also there's a risk that the employee may not, in fact, have the money to repay you. So that goes to the importance of a carefully drafted clawback provisions. If the clawback provision allows you to reduce certain payment which are not vested to the employee yet, this may maximize the chance of the employer to recover the payment. Reduction is not prohibited under the employment ordinance. Only deduction from wages is prohibited. Next slide, please. So in order to maximize the chance of recovery of payment, we would recommend employers to include both a clawback provision and a malus provision in your bonus policy. Clawback means the employees are required to pay back all or some of the amount they have already received. So it deals with the vested portion, money already in the pocket of the employee. Another provision is malus provision. It refers to an adjustment, usually downward adjustment of the incentive to be awarded to the employee and before they become payable. So we are talking about the unvested portion. So in relation to both the clawback and the malus provision, the trigger event must be carefully drafted. I would say it's a balancing exercise. It should neither be too restrictive, as it may not cover all the possible circumstances for clawback or adjustment, nor it should be drafted too broadly. If there's any ambiguity on the terms of the trigger events, the court in Hong Kong will construe the term against the party which prepared the policy or the agreement. That is the employer in the case. It would be good for the employers to include in your bonus policy a discretion to decide when the incentive was erroneously paid. Although the discretion is not unfettered, the court in Hong Kong generally will not interfere with the decision unless such decision is irrational, in a sense that no employee in similar circumstances will make the same decision. So the threshold is, in fact, pretty high. It's also a good practice to keep a record of the exercise of discretion and the triggered events so as to ensure consistency in the application in the future. One final note, an employer cannot enforce a policy unless it has contractual force. So the terms and the policy must be communicated and accepted by the employee. You can incorporate the policies into part of your contract of employment or the policies into bonus award letters and get the employees to accept those terms. So that's all for Hong Kong. Over to you, Jack.
Thank you very much, Jennifer. And thank you everyone for joining today. Good to be with you. My name is Jad Taha. I'm a partner with Mayor Brown's Dubai office. Next slide, please. So I want to start off by, without going into too much detail here, but just an overview on the legislative framework in the UAE. The UAE is made up of multiple jurisdictions, mainly divided between mainland UAE, that's your onshore UAE jurisdictions that would cover the Emirates of the UAE outside of free trade zones. And that onshore jurisdiction is governed by the UAE federal labor law at the federal level, but then you have at the Emirate levels, very much similar to the state law, you would have Emirate level based employment laws. And then within free trade zones, you have, in some cases, not all free trade zones, but some free trade zones have their own employment law as well, most notably the DIFC and the ADGM. So these are the two financial free trade zones in Dubai, sitting in Dubai and Abu Dhabi. And I mentioned this just as a general overview, but there's really a common link here between the various laws and regulations across the UAE, which is that Clawback is not directly addressed in the UAE law. I would note that UAE laws and courts in general are fairly protective of employee rights. All the more reason to take prudent steps in terms of how we draft clawback provisions, and we'll get to drafting points on drafting in the next couple of slides. And as I mentioned, there's no local law that prohibits the enforcement of a policy that requires the recovery of certain erroneously paid executive compensation. What comes close to that in terms of coverage is Article 25 of the labor law, of the federal labor law, that provides for cases of deduction or withholding. And there are different requirements for that, different triggering events. The first being certain loans that are granted to employees that can be recovered in subsequent compensation. Contributions to bonuses, pensions, savings funds, and insurance in the UAE. As of late, there is a countrywide initiative to roll out savings funds, mandatory savings funds for employees that employers would need to contribute towards, and so that would fall there. Any participation in social projects provided by the employer. That's particularly settled debts that's pursuant to any judgments that are issued in the UAE, and then any committed violations, and these are established violations that have been established as committed under UAE law, and those should not exceed 5% of the salary. But whatever the category that we're looking at, percentage of deduction or withholding should not exceed 50% of the employee's salary. Now, the law is not specific in terms of whether this is annual or monthly, but with everything in the UAE, the reference is often to monthly salary. So that would be assumably a safe assumption in our view that this is essentially the cap here is, or the ceiling is 50% of an employee's monthly salary. Next slide, please. Looking at and considering deduction from future compensation. So as we mentioned, there's no provision under local law that expressly prohibits the deduction of erroneously paid executive compensation from future compensation payable to any executives. What often takes place is there would be a deduction of, let's say, overpaid bonus from future compensation by taking from different buckets. So that this can be, and it's permissible to be, from base salary or future bonuses or any other form of compensation. So there's no prohibition on deduction or limitation on deduction being taken from any particular categories of or forms of compensation. There is an Article 51 of the labor law that expressly provides for the deduction of an employee's or from an employee's end of service benefits when it comes to any amounts that are payable under law or by judgment, and those include amounts that are listed in or amounts related to triggering events that are listed in the previous slide. And end of service benefits essentially is a very commonplace form of benefit in the UAE. It's afforded as a termination benefit for any employee who is not only terminated, not for cause, but resigning as well. So any resigning employee would have a right to end of service payout, and in cases of termination as well, as long as they're not for cause, and for cause is a term that's specifically defined in the federal labor law, as well as some of the other laws and regulations across the UAE and some of the free zones. And what typically takes place is you'd have a termination letter And that termination letter would break down the end of service that's afforded to that employee. And oftentimes, employers who are not too sure about the enforcement of clawback concepts or clawback provisions, even in employment contracts, tend to wait until resignation or termination if that event is anticipated or reasonably anticipated, and they would account for any deduction in end of service, given that Article 51 is fairly clear with respect to employers' rights to deduct from end of service, and they would establish that deduction as part of the breakdown in that termination letter before the termination or resignation of that employee. Next slide, please. Diving a bit deeper in terms of just how contracts are structured in general, and to Ryan's earlier point that these are enforced by contract as opposed to by statute, and similar in the UAE, especially in the absence of any statutory provisions on clawbacks, at least ones that are expressed to clawbacks. What ends up happening is you have two types of contracts, employment contracts in the UAE. You have what's known as a mandated employment contract, and that is usually a Ministry of Labor mandated template employment contract, or in the case of free zones, the free zone regulators mandated employment contract that would need to be used by or with employees. There is very little room for amendment or adjustment of the template, that particular template, and especially in the UAE, given that essentially 90% of the workforce is made up of expatriate employees. Non-UAE nationals make up 90% of the workforce, and so they would have a template employment contract with very little deviation from what's mandated by the employment regulator. That contract would be filed with the regulator for purposes of, among other things, sponsoring that employee for an employment visa under the sponsorship of the employer. But given the very little to no room for deviation from the template, employers often use a supplemental employment contract, and that supplemental employment contract is a private contract. It's not filed with any regulator, and perfectly permissible under UAE laws and regulations to have dual employment contracts, as long as that doesn't there's no contradiction between the two employment contracts, and the supplemental employment contracts would supplement, as the name states, supplement the standard employment contracts filed with the regulator. And there is where you would house clawback provisions as much in detail as you would like, and you would take up much of the drafting approaches and considerations that you would in other jurisdictions like the US or Hong Kong or otherwise. We typically review those to make sure that they're not in contravention of any local considerations, any local laws, but for the most part, there's very little tailoring when it comes to clawback provisions from a UAE perspective. You're adopting very much international best practices, US best practices, UK best practices when it comes to clawback provisions that are being housed in supplemental employment contracts. And you can even, in some cases, if you're taking a more conservative view and approach to things, you would have that supplemental employment contract governed by non-UAE law, by New York law or UK law, what have you. And that's enforceable in the UAE, generally speaking. There's a general freedom of contract, and as long as, again, there's no contravention with local laws, you can have that supplemental employment contract governed by foreign law. It's not common. You'd need to have employment contracts for various reasons, preferable to have them both governed by UAE law. But if you were to take a conservative view, you want to make sure that clawback provisions are are essentially, there's comfort around those provisions and the way they're drafted. You can have them subject to foreign law. Now, essentially, as I mentioned, there is very little tailoring to be made from a UAE perspective. But one thing to note is policies should, and preferably should, include references to Article 25 of the labor law, and that's the provision that we referenced in the earlier slide when describing triggering events or cases where an employer has the right to deduct from compensation, including future compensation. Employers need to be prudent in terms of drafting the policy so it's not deemed as a penalty. That's the big no under local law among very few when it comes to clawback provisions or any type of provisions related to compensation or liability. And it should be clarified that they're not taking the form of penalties and they're just in accordance with UAE labor law. So a reference back to Article 25 of the labor law. And of course, as we mentioned earlier, many employers, and often is the case where any deductions would just be sorted through or by way of the end of service benefit. And so you'd have that letter that breaks down everything that needs to be deducted from end of service. There would be reliance on that express provision under the federal labor law that provides for those deductions that are with respect to dues from the employee to the employer. And as long as the employee signs off on the end of service letter or the termination letter, and that's really what you would need if you want to go through a seamless process of terminating their employment, terminating their employment visa, and just divorcing, essentially. You would have that employee sign off on the termination letter with those deductions in place. And as long as you have mutual agreement on that, there is very little to no risk, really, exposure in terms of having any challenges with respect to clawback provisions in the supplemental contract, if there is one, or the deductions themselves that are laid out in the termination letter.
So good news first for Germany. There is no law that prohibits the enforcement of clawback policies in general. And when I say that, I mean the clawback provisions that we talked to in this context here. So clawback of erroneously paid compensation that is asked for if a financial statement needs to be restated. It is not a general permission to include clawback provisions. There may be other situations that we from time to time see with clients. After a good year, there's a bad year, and the client says, oh, we have a bad impact on our financials. We would like to get back some of the compensation already paid. That's a different situation, and that's not generally covered here. What everyone should know is that German law has very strict requirements in terms of transparency and clarity of contract language. That also applies to clawback clauses, clawback provisions in compensation policies. There's specific provisions in the German civil code that are very employee-friendly, and such provisions apply to any clause agreed upon between the employer and their employees, and such clauses should be considered when drafting clawback policies and provisions. So how to avoid the restrictions of German law on general terms and conditions. So ideally, clawback rules are included in a compensation plan that's governed by US law. That sounds like a very simple and easy solution, just to state it's governed by US law, but that doesn't always work. German courts always take a close look at the plan itself and make a case-by-case assessment as to whether the choice of foreign law, in this case here US law, is actually enforceable. And there are different aspects courts consider. One would be to look at the plan and determine based on whether the plan is, let's say, equity-based or cash-based. Equity plans have a greater chance of being governed by US law because German courts accept that there may be certain requirements in the corporate law that applies to the corporate seat of the company operating the plan that have to be honored. And in this case, courts are very reluctant to apply German law. If we look at cash incentive plans, it's a different story. There is not that corporate law argument that can be applied. And in cash incentive plans, courts in Germany often tend to view such plans as being part of the local employment relationship, and therefore apply German law also to any plans that include clawback provisions. So similar to what Jennifer described earlier for Hong Kong, German law also includes special rules for the banking and financial industry, and here also on compensation for management and supervisory board members in stock corporations. In Europe, so in Germany and Europe general, this is based on EU law. So the EU Capital Requirements Directive has defined certain requirements in terms of the monitoring of, let's say, banks' capital stock, for instance, that has been implemented and transformed into the German Banking Act. And there's a special, let's say, ordinance. It's the German Remuneration Ordinance for Institutions that defines very specific malus and clawback requirements. So let's go to the next slide, please. So now about enforcing it and deduction. German law does not expressly prohibit companies from deducting erroneously paid incentive-based compensation from future compensation payable to the executive, but there are a few practical considerations to be made. One is that the entity that wants to deduct overpaid remuneration from future compensation needs to be, in both cases, the same entity. So you cannot say there's a clawback right on the part of the, let's say, US parent entity, and that asks for a deduction of any local short-term incentive bonus, for instance. So it needs to be the same entity. At least we would need to include a certain mechanism in the plan provisions on how to, let's say, transfer and assign a clawback right to the other entity that owes future remuneration. Can it all be reclaimed? No, there's a certain amount that's protected against garnishment, and that so-called garnishment exemption amount also needs to be considered in case of an offsetting of, let's say, a repayment claim against employees or executives' compensation entitlements. It's a fairly low amount, 4-digit figure per month. Big question is, can you ask for the gross amount to be paid back or only the net amount that was paid out to the executive? It's similarly unclear as it is in the US, so there's no clear guidance. There is a tendency in German law to say employers can always only reclaim the net amount, and when it comes to social security contributions and taxes, the employer has to get in contact with the respective authorities to which the employer paid the tax or social security contributions, and it's a business risk for the employer. I understood from Ryan's comments earlier that the big question is what the motivation of the rules is. Is it to prevent the executive from benefiting from incorrect financial statements, or is it rather about ensuring that the company is put into the same financial situation as it would have been without the incorrect financial statement? That's a good question. And with the argument of not allowing executives to benefit from such mistakes, I think that argument would also be a good one here in Germany. And I would definitely recommend to include a, let's say, rather sophisticated clause regarding the net or gross question in the agreement. In the end, you can always fall back onto the net repayment, but there's a good chance that in this scenario here, a clawback of the gross amount could be enforceable. Next slide, thank you. So what are the do's and don'ts or the takeaways? This is some of those are similar to what you've heard before. One maybe unique recommendation for Germany is to always try to roll out and implement a global plan over any localized plan. So once you localize the terms and conditions of an incentive plan in Germany, there's a higher risk that a court will look at the plan only from a German law perspective. If it's a, let's say, global plan that's operated by the US parent entity, there's at least a chance that courts will accept the choice of US law. We've been through such discussions several times, and whenever there was a clear global plan without any involvement of the local employer in Germany, we were usually successful to convince the court that this is only to be looked at from a US law perspective. Then the recommendation is to insert a clear reservation that payments remain subject to later correction and clawback in case of a restatement of financial statements. What German law also recommends is to insert a time limitation. There's no clear and fixed number of years. The maximum that should be considered is 5 years. That is a time period that we also find in the Stock Corporation Act and the provisions that apply to compensation for supervisory and management board members. But for employees who are not at management level, a shorter period of time, 2 to 3 years, may even be preferable. The plan should clearly describe under what circumstances clawback will apply. So just a statement like, we reserve the right to reclaim any erroneously paid amounts that would not be sufficient and would not survive the, let's say, the test in German courtroom. The clawback should also in Germany not appear to be a penalty. Policy should clarify whether gross or net repayment. We went through this already. There should be a clause reserving the right to offset repayment amounts against future compensation entitlements. And in the end, that is similar to what Jennifer described for Hong Kong. The policy should ideally differentiate between clawback and malus provisions. So the malus provision in a situation where payment has not been made yet, and clawback would apply only to payments that have already gone out to the executive. So thank you for listening, and now I hand it over to Julian to talk about France.
Thank you again. Good morning, everyone, or good afternoon. I don't know, maybe good night. I don't know. I'm Julian Auer. I'm the employment partner in the Paris office. So first thing that we can say is that France is not the El Dorado of the clawback, for sure. This is particularly tricky to enforce in France because of mainly 2 principles. The first is that there is a strict prohibition of the pecuniary sanctions. So every clawback that would be linked to disciplinary matter would be considered as null and void. And of course, every provision, any plan that would provide for this kind of rules would be considered as null and void. This is reinforced by the fact that there's a huge tendency of the Supreme Court to extend the scope of this invalidity of the clawback. It tends to apply also to, for instance, non-disciplinary matter. If you are simply a poor performer, which does not mean that you made a misconduct, but if you are a low performer, likely any clawback that would apply to you would be considered as null and void as well. So this is a strict principle in France that unfortunately limits the scope of the clawback. And if the clawback is provided by a plan which is ruled by a foreign law, like US, for instance, it does not help because the employer or the company that will issue the plan could not rely on this law because the employee will be submitted to French law, and it could say, because I'm working in France, the French law applies to me, and this is more favorable to me than the provision of the plan that are ruled by the US law. So this is the first impediment for the enforcement of clawback in France. The second one is that most of the time, the way that the clawback is provided or drafted could lead to enter in conflict with imperative protection of fundamental rights, like the right of ownership, which is under French law, but I think in other jurisdictions, but considered as a fundamental right protected by the Constitution. So, for instance, this occurs often with clawback on vested equity. When you say to an employee or former employee, okay, we will claw back your vested equity if, for instance, you go to the competition in infringement of your non-competition clause. This will not be possible because it will enter into conflict with this fundamental right. So this is the main issue, the two main causes that limit the enforcement of clawback in France. Next slide, please. Still, it does not mean that clawback is not totally absent of the French legal panorama. Because of some big scandals in France, maybe you remember the Société Générale, the trader that made some risk-taking position and that exposed the Société Générale to 5 billion euros of risk. Because of that, there's a new legislation that has been entered into force in France. And then it only applies in the finance and bank sector. So as you can see, it is provided by an article of the French Monetary and Financial Code. And this code this article expressly authorized the clawback. It's only concerned credit institution, finance companies, payment institution, and so on, as mentioned in the slide. And it is quite limited because it's only concern failure to acts that leads to the failure to comply with the rules laid down by the company with regard to risk-taking positions. In particular, when this leads to losses for the company, but not only. The only fact that you can make some risk-taking position could lead to the enforcement of the clawback. The second potent qualifying acts for the clawback would be when you failed to your obligation related to honorability and competence. This is quite broad, so it leaves some room to the companies to enforce the clawback, but which is not let's say surprising, because this provisions applies to person who has a really high position within the company. So as you can see, it's only members of the boards, director, supervisory boards, people that have a control function on the establishment of the company, or that leads to major business units and that reports directly to the board. And also people who, even though they don't have these management, positions or functions, are very well paid. It's at least €500,000 and this person was also carrying out some professional activities that likely could impact the risk profile of the company. So this is something that it's now applying to traders, for instance. So traders are concerned by this kind of legislation, and it is quite common in the bank and finance sector. Next slide, please. But what about the other sector? Because as I said to you, the clawback is not totally absent of French law. So here I put some takeaways so that if you want to implement a clawback plan in France, this could work. First thing to really understand and put in clearly in the plan is that the clawback will not be enforceable because of the employee misconduct. This refers to the prohibition of pecuniary sanction that I mentioned earlier. If you do that, it will be considered as null and void. So what we do in France generally, it's to circumvent that, it's to put a condition of presence. So let's say if you dismiss someone, and rather to say, okay, we will claw back this amount to you if you are dismissed for misconduct, you would say, we will claw back this amount to you if you are not present at the company at this time, at this date. And then if you dismiss the employee, whatever the ground, including for misconduct, you could apply the clawback. Of course, you never link the clawback to non-objective criteria. So if you say this is discretionary or based on, I don't know, the appreciation of your management, this kind of things, of your work by the management, this will not work neither. Second thing to put in the plan is to clearly specify how the clawback will be triggered, when and how. Generally, it's just, okay, in some plan that I could have seen, it's just mentioned, okay, we can claw back this amount if blah, 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 but it does not mention when, how, and this is something that really needs to be put in writing in the plan, and the employee must be informed in writing of how it works. So it is just the next bullet point. It needs to know exactly how it works, and it needs to know at the time that the amount that could be clawed back be provided to him. One thing which is tricky to implement is that the terms of the clawback must not lead to prevent the employee from exercising the fundamental right in France of resigning. So right to work in France is really as well a fundamental right. So normally you can resign. And of course, this could be limited by non-competition clause and so on. But if the terms of the clawback plans, it's too disproportionate compared to, for instance, what the employee is paid, or is too disproportionate in time because it's too lengthy in time, then it could be considered as breaching the fundamental right of resigning, and then it could be considered as null and void as well. Lastly, and this is something that is usually forbidden, but to be really effective, this kind of clause needs to be written in French. There's a huge, let's say, requirement from French judges that any plans, any provisions that restrict the employee's right or that impose some rights or some duties to the employee be in French, so that there's a full understanding. If, of course, the plan is in US, is ruled by the US law, at least my recommendation would be to provide a clear and full acknowledgement and understanding statement at the end of the document to be filled in and signed by the individual. But again, French, it's better. Two more comments, even though only one is mentioned here. First of all, payment errors do not create any enforceable rights for the employee. So it means that if you pay something by error to an employee, of course, you can claw back this amount. This is a constant civil law principle that has been recognized by the Supreme Court. Second thing that is not mentioned, but it's in echo with what Agan just said, is that when you want to claw back in France, so of course you cannot claw back all the amount. This is some limits because you cannot, let's say, retain all the salary of the employee or all the components salary of the employee. This is the first thing. But the second thing is that you will have to go before the court. And I don't know how long it takes in other jurisdiction, but in France, it can take a lot of time to get back the money. So you have to make, let's say, a balanced decision between, okay, is it in my interest to lose maybe years fighting this case, paying a lawyer to get back the money, rather than giving up and let's say not claw back the money. This is an arbitration that any employee should have to do before enforcing the clawback. It's all for France. Thank you, and I over to you, Chris, for UK.
Thanks, Julien. Hello, everyone. Morning, afternoon, evening. I'm Chris Fisher. I'm the head of the employment team in the UK at Mayer Brown, and I'm going to talk about clawback in the UK. Clawback in the UK is very common. It's been common for a number of years. We had it really since the 2008 recession, which is when listed companies, so similar to what's happening in the US, listed companies were required or encouraged at least to apply a form of clawback to remuneration, at least for directors. And that's now in our what's called the UK Corporate Governance Code, which applies to listed companies, but a number of large non-listed companies will adopt clawback to try to mirror that. It's also a regulatory requirement in financial services firms, which a number of my colleagues have talked about ever since the banking crisis. That really, the FCA and the PRA, the two main regulators in the UK, require regulated firms to apply clawback to remuneration for certain of their staff, specifically staff known as material risk takers. So it's a very familiar concept to UK employers, and as again, a number of my colleagues have commented, we have two names for clawback. We have malus, which is forfeiture of unvested awards, and clawback, which is actually clawing back awards that have already been vested and delivered. The triggers for clawback, because I think the UK is deemed to have one of the most severe forms of regimes for clawback against executives. The triggers have become broader over the years, and they're not just misstatement of financial results. That will always be included, but it will include some of the more subjective things that I know would not find favor in jurisdictions like France, such as misconduct, employee misconduct, reputational damage, corporate failure. Certainly is one that shareholders will expect to be included in the list of trigger events. But the key point to bear in mind, despite the fact that the UK has this regulatory regime, is that they don't quite have the force of law, and so companies and firms do need to implement them in their contractual documentation. It's not enough just to rely on the fact that the regulator requires them or institutional shareholders encourage them. There has to be a contract in place. So it has to be drafted into the incentive plan documents. So next slide, thanks. So the key thing, I think, a number of the concepts are similar to those that my colleagues have made. I think the key thing from the UK perspective is that amounts can be deducted from other remuneration, and that is fine to do that, with one proviso, which is that the employee in question must have agreed in writing to that, and so that means having the employee expressly sign up to the award agreement when they receive the award, to say that not only do they accept the terms of the plan, the terms of any clawback policy, but also the fact that they accept that in the event of a trigger event, the award can be subject to malus or clawback from other of their remuneration, and that may be under that plan, or it may be under another plan, but it has to be an express written acknowledgement from the employee. Otherwise, any attempt to deduct from an employee's pay would be unlawful under English law, under UK law. So that's really the key point to bear in mind in the UK. Clawing back from other awards is possible, and again quite common. We call it cross clawback, and that where, quite as the name suggests, where you look to another award somewhere else, possibly that's been granted under another plan, and you look to claw back against that. That often will mean perhaps clawing back against an unvested award, which may be seen as easier. It may avoid some of the tax issues avoiding the need to compare gross and net recovery on a tax basis, and so that is quite common to look to do. I think if you do have clawback, one thing to bear in mind then is, are you going to draft into your policy? Where will you look to apply cross clawback? And you see policies sometimes saying that there'll be a reference to the size of the award will be relevant to it, likelihood of how close is the other award to vesting, and how likely is it that it will vest, as to ensure that the shareholders and regulators see that that clawback is being applied properly and not just against an award that perhaps will never have vested, and so is not true clawback. Next slide, please, Emily. Thanks. The last point, just to mention, in the UK, I was going to mention 3 drafting points. A lot of the drafting points, again, are similar to the other jurisdictions, but there's been we've talked about the clawback triggers, which is obviously extremely important, and there's always, I think, a debate as to how broadly or narrowly you draft your clawback triggers, and it's a difficult one. There has to be a balance, I think. If it is too broad and too vague, as Hagen said, it's going to run the risk that not only might it not work contractually because it would just be too vague, but it will allow too much room for argument that, you know, the event that's happened isn't caught by the clawback trigger. Similarly, though, if you're too specific and you try to list out every single example of a clawback trigger, you may miss one, and you may miss the thing that actually happens, and then you won't be able to claw back against that, because the courts will be quite restrictive. They will look at what you've drafted, and if it doesn't fall within that, they won't allow you to apply the clawback. And there have been a number of cases in the UK courts where employees have successfully sued to avoid having money clawed back because the plan didn't cover what had happened in practice. Second point on cross clawback, if you do want to apply the ability to achieve cross clawback under another plan, bear in mind that the relevant cross clawback provisions need to be in both plans. They also need to be in the plan that you're going to go against, as well as the plan where the clawback trigger has happened. And again, if you're applying, you'll need express employee agreement to deduction from the future remuneration in both plans. So you'll need to look not just at the new plan you're introducing, but the plan that you're looking to apply cross clawback against. And finally, the one area where decisions have been challenged in the UK courts in the past is where there is a discretion available to the company, or indeed where they have had some latitude in whether they apply a trigger or not. There can be a challenge that employers and companies haven't acted rationally or reasonably. And so what's helpful, where it may well be that different decisions will be made in different factual scenarios, is to keep minutes. So that's a sort of compensation committee point. Keep minutes of those decisions so that it's more difficult for employees to challenge perhaps why one decision is not quite the same as was applied against another executive on another day. That's it from me from the UK. I'll hand over to Aline in Brazil.
Thanks, Chris. I'm Aline Fidelis from Brazil. Good morning, good afternoon, good night to everyone. In Brazil, it's important to highlight, first of all, that there is a difference between employee and non-employee officer. It's common to have executives hired by both categories, so it's important to highlight the difference, because to have the payment back, you have different rules. If you are a non-employee officer, the rules provided in the policy and in the contract are enforceable to reimburse the company if the payment was paid erroneously. So we have to have a clawback policy, and the non-employee officer will agree with this policy. In summary, a non-employee officer is a director that is appointed in the company's bylaw, and there is no employment contract with his or her director officer. Unemployed in Brazil means that the worker hired and that there is an employment booklet with this employment contract registered. In summary, is the worker that is subordinated to the company, and the employee has some mandatory labor rights provided by law. Considering this difference, next slide, please. Considering this difference, if we are in a scenario that we have an employee hired by the company, the deductions has to be in compliance with a specific Brazilian law. This law is similar to France because in a general rule, the company is not allowed to have payments back from the employees. But this specific law will provide the company with scenarios that the company has the right to receive the payment, the incentive payments, stock options, other payments back. We have to be in compliance with the percentage that the company would be allowed to deduct from the employee will be 30% of the monthly employee salary. So provided by this law, this Brazilian law, if the company wants to have this money back, there is this rule, this cap, this monthly cap, but the company could do it every month until the cap of the amount will be returned to the company. For instance, 30% next month, 30% in the month on December, 30% on January of 2024, and so on. Next slide, please. In summary, to have the clawback policy enforceable in Brazil, our recommendation would be to have different rules for these two types of employee and non-employee officer. For employees, it's recommendable to have the consent in the employment contract, considering the provisions about Brazilian labor law. So the employee will agree that in some situations, the amounts will be deducted in the months, subsequent months, in case there is a erroneous payment or in case the clawback applies. It's important to have this consent. So it's a kind of mutual agreement. For non-employee officer, it's also recommendable to have this consent, but it's not mandatory because the contract laws will apply, and the contract laws in Brazil will be the enforceable basis to have this money back. Besides that, it's important to have the consent of employees and non-employee officers in Brazil about the policies, all the policies that are applying in the relationship, especially this kind of clawback policies. So I think that's for Brazil, that's all.
I want to thank all the panelists. I am always impressed. Particularly, I want my own personal admiration for those of the panelists who are presenting in a second language. I feel like practicing law at this level in your first language is hard enough. And I'm always really impressed with those who can do it on a bilingual basis. And again, one of the great parts about this firm is the international perspective. So I appreciate the panel, everyone who took the time to participate, and thank you all for joining. And again, follow up if anybody has any other questions after the program. Thanks.